Special notice for government, election petition 6/2009.
Yeah. In view of my findings in respect of issue numbers 1 to 3, 4 to 14, 17 and 21, 22 to 27, and 28, 30, and 32 in favor of the election petitioner, I hold the election petition to be maintainable in the eyes of law. The election petitioner has disclosed sufficient cause of action to file the election petition. The election petition is not liable to be dismissed under Section 86(1) of the RP Act 1951. The nomination papers filed by the respondent were not in the prescribed Form 2B. The returning officer has illegally and improperly accepted the nomination papers of the respondent, violating the mandate of Section 33 of the RP Act, read with Rule 4 of 1961 rules, and the instruction issued by the Election Commission of India in exercise of power under Article 324 of the Constitution of India. The striking/deletion of Part 2 of the nomination in Form 2B by the respondent in pursuance to the instruction given in the prescribed nomination Form 2B renders his nomination liable for rejection. The respondent has not furnished all the required information in Part 3 and Part 3A of the nomination form 2B. The defects as pointed out by the election petitioner regarding deletion of Part 2 of nomination form 2B as well as with respect to Part 3 and Part 3A of the nomination form 2B are substantial defects. Part 3 of Form 2B of the nomination papers filed by the respondent was not in the prescribed form. The column numbers 3 to 9 of Part 3A were not in the prescribed Form 2B. The nomination filed by the respondent was not rightly accepted by the returning officer as prescribed under Section 36(4) of the RP Act 1951. The returning officer should have rejected the nomination of the respondent in exercise of the power under Section 36 of the RP Act 1951 at the time of scrutiny of the nomination papers. The respondent has not made proper and full declaration about the 13 criminal cases pending against him in the affidavit filed in Form 26. And on account of the defects as pointed out by the election petitioner, the result of the election, insofar as it concerns the written candidate oblique respondent, has been materially affected, and it cannot be said that the respondent was duly elected. In view of my findings in the previous paragraphs, election petition number 6 of 2019 is allowed, and it is
Deeply obliged, my lords.
that the election of the respondent as MLA from the 90 Varavati Cuttack Assembly constituency held in April 2019 is void, and the same is hereby set aside. Resultantly, in view of Section 150A of RP Act, a casual vacancy to the said constituency has occurred. Before parting, I deem it proper to place on record my deepest sense of appreciation for the able assistance rendered by Mr. Milan Kanungo, Learned Senior Advocate, being ably assisted by Mr. Gopal Agrawal, Learned Counsel, and Mr. Vidyadhar Mishra, Learned Senior Advocate, being ably assisted by Mr. Taranikanta Biswal. All of them wholeheartedly devoted their time and energy in the preparation of the case. The proceeding got delayed on account of COVID-19 pandemic, and then for the disposal of interim application filed by the respondent for striking out the pleadings in some paragraphs of the election petition with a further prayer to reject the election petition at the threshold, which was dismissed by me as per order dated 26/2022, which was later confirmed by the Honorable Supreme Court by order dated 29/7/2022. The issues were framed on 14/10/2022, and the Learned Council fully cooperated for early disposal of the case. I express my gratefulness and indebtedness to the Learned Council from the bottom of my heart.
Deeply obliged, my lords. Deeply obliged. Deeply obliged. Lords, your lordships have also taken a lot of pain, my lords. Lordships have, I'm on VC, my lords. Your lordships, I'm on VC, my lords. Your lordships have taken a lot of pain, my lords, in this matter.
Thank you, Mr. Kanungo.
Thanks,
Yes.
my lords. My duty to thank your lordships.
Deeply obliged, man.
పన్నెండవ మెన్షన్ వల్ల PC Act CRL
Please.
On a tied-up matter and criminal appeal for bail. Lordship, criminal appeal 2018 matter, paperwork is
Please.
also ready, Lordship.
Give it.
May I be permitted to make a mention, my lords? I am on
Yes.
PC. The phrase criminal appeal, 3 years is the sentence. Criminal appeal number 162 of 24. I have filed a memo, but it has not been listed. Fresh matter.
Will come tomorrow.
Oblige me.
I may be pardoned, your lordship. Item number 70 and 77 kindly be taken up 1 week after.
Mentioning
My lord, because a connected matter is pending before another bench
70
of
and
77.
is there any stay order?
No, my lord.
So if it is not there, then it's okay. We'll verify and stay. Yadi stay order
Actually,
not.
another matter is pending before another bench 70 and 77. Your lordship.
Just a minute. Just a minute. Let him come.
Weekly list item number 1.
May I please have wishes? I am challenging the judgment of conviction and sentence dated 16/1/2024, by which the appellant has been convicted for 304 Part 2 and 306 IPC, Your Lordship. Under Section 304 Part 2, I have been convicted for 8-year and 8-year rigorous imprisonment along with 5,000 fine.
Right. Admit.
Pardon, Your Lordship.
Call for the trial court record. Deposition copy to be supplied to the Land Council for the state. Interim application for bail and stay realization of fines to be considered after receipt of the trial court report.
Lordship, I was bail all along through the trial, Your
That
Lordship.
will be considered. Supply first the deposition copy.
I'm just now supplying the
Yes.
deposition
Next.
copy. Lordship, may kindly
Item
take this
2.
matter to next week since the petitioner is a lead.
See, yes, next item 2.
Your Lordship, I was only praying for. I'm just supplying the deposition copy, sir. Much
Deposition
obliged.
copy supplied in court. Yes, next.
Much obliged.
Item 2.
May I please, Your Lords? Appellants have been convicted.
Item 4.
May I please, Your Lordship? The appellant convicted under section
Item 5.
May I please, Your Lordship? Lordship on last occasion directed me to produce the certified copy of the deposition copy of the victim girl.
Yes.
I'm
Have you supplied a copy to the Land and State Council?
No, I'm not supporting about.
Victim supported the prosecution case.
Supported the prosecution case and
Then
in cross examination.
Supply him. Will take up the Land and Council for the. Have you got a copy with you now?
Yes.
Okay. Hand over to Mr. Das.
Lordship, this Lordship, we may kindly have a glance to it. The victim girl.
Why didn't you earlier supplied the deposition copy? His victim is PW. How do you argue the matter? You are not having a copy of.
No, Lordship. Only I have made a one copy which I have supplied to Mr. Das.
This has been thankful Land and Council for the appellant files the certified copy of deposition of the victim in court today, which is taken on record. He undertakes to supply the copy to the Land and Council for the state during course of the day.
That's it.
Okay. Put up this matter. We commencing from 11th of March 2024. You have received the case diary? Okay.
Item 6. Item 7.
7 and 9 can be taken up.
7 and 9. Yes.
On behalf of Mr. Chand, I prefer an adjournment.
Adjournment till
1 week, my lord.
1 week. Mention is made on behalf of Mr. Manas Kumar Chand to adjourn the matter for 1 week. Learned counsel for the state has received the case diary. This matter is connected to item number 9. That is CRLA number so and so. Both are urgent. Fix a date.
Item 8.
What is the defect number 9? Legible copy so and so. Okay. You have received the case diary?
No, madam.
None appears for the appellant. Learned counsel for the state also submits that he has not received the case diary. So also the instruction about the criminal antecedent. Case is urgent. Is this matter on such and such date?
Item 9.
9, please, madam.
9 is urgent.
9 से आपके कोर्ट से सेट
9?
सेम रसात संग सेम थला तो
Mr. Counsel, it is connected to item number 7 and a mention is made on behalf of Mr. Chand to adjourn the matter. So since both the matters are connected, it will come together. All right? Yes. You have received the case diary, no? CD case diary has been received. But since one of the learned counsel seeks for an adjournment, so it will come next week. Okay? Yeah.
Item 10.
May it please your lord. The petition, the appellant is charge sheeted.
Mr. Pujari, please use the mic properly.
The appellant is charge sheeted for offences under 147, 148.
You have received the case diary?
is connected to BLA, let it be.
I had given an affidavit along with the documents received from the Surat jail that on the date this offence took place.
That's another matter.
Another matter your lordship had already allowed.
So take up tomorrow or day after? Tomorrow. All right. Learned
In
counsel.
fact, last time they were confused because Tankar na again Bapankar na lekha. That is the reason why confusion was there.
Yes, got it. Tomorrow. All right.
Along with Setra Asu, 1221 appeal.
Who matter kile?
I would do that case.
No, it will come along with that.
Along with that, asila Setra upon day side chanti.
Okay. That's a dispose of case.
That is a disposed of case.
All right.
1221
The CRLA number 1270 of 2023. Learned counsel for the petitioner submits that that was also filed by the petitioner. Another bail application of the petitioner in CRLA number 1271 of 2023 has been disposed of and that file may be called for. Learned counsel for the state submits that he has received instruction in the matter. As prayed for, put up this matter tomorrow along with CRLA number 1271 of 2023.
Item 11.
Mr. Roy.
If I may please your lordship, my lord.
Yes. Notice sufficient, Mr. Das?
Yes, sir.
Kebe.
Item 11, my lord.
Yes. 11 notice ଆସିନି madam. We have sent already, not received. Let it be next week, madam. CD also not received. Okay. Learning counsel for the Mr. S. Saurav. Learning counsel for the
Earlier
appellant.
it was rejected by Honorable Justice B. Nursing.
But maybe
TRLA,
first one has
no,
been dealt with by me. Let me see that.
Your Lordship, what had happened was that was then an original bail application under 439, and after filing of charge sheet, because there was SC/ST Act, it was converted to criminal appeal because a bail application would not be maintainable, and it was by His Lordship's order that it was converted and then sent to your Lordship.
No, since the BL appeal earlier, this was also for bail. The
My lord, I
earlier
do not
one
know
was
that.
also for bail. Let the registry take instruction
As your
from the
Lordship pleases.
Honorable Chief Justice.
As your Lordship pleases.
The learning counsel for the state has pointed out that the earlier bail application of the petitioner in BLAPL number
BLAPL number 9535 of 2023.
9535 of 2023
Your Lordship.
has been disposed of by a coordinate bench. And this CRLA is also an application for bail. In view of such submission made by the Learning Council, the matter be placed with in the appropriate bench with the approval of the Honorable Chief Justice.
I'm grateful, your Lordship.
Item 12.
May I please, your Lordship? If the notice was issued to the informant.
Notice or mailed on 4/3.
4/3 to Aji.
Morning they have.
Oh, Aji mo sorry. Then I have to give time. Baki, you have received the case diary?
Also collected.
All right. The Learning Council for the state submitted that notice on the informant has been made sufficient today. And he has not also received the case diary. So also the instruction about the criminal antecedent, if any, against the appellant, in order to give time to the informant to engage his counsel of his own choice to oppose the prayer for bail, put up this matter in the week commencing from 18th of March 2024. Case diary and instruction about the criminal antecedent be obtained in the meantime.
Maybe last time, 18/12/2023.
All right. It is made clear that no further adjournment shall be granted.
I may be pardoned, your Lordship. My Lord, item 11, let them also obtain the CD in the meantime, my Lord.
CD টা আসেনি ফ্ল্যাগ ওকে তাদের সিডি লাগে
I'm grateful.
जोटा हाँ जोटा এই যে কেস ডায়েরি भी obtain in the meantime हाँ
Obliged.
CDCA कर दियो
Item 13.
এটা লাস্ট চান্স লিখে দেবে তো আগুর আটজন
May I please, your Lordship? Item 13, your Lordship. I pray your Lordship kindly take a
Item 15.
15 minute notice was issued. Also on the next week, my lord.
No, you have
CD
received the case diary
No, CD also not received.
and notice also no.
No,
It has already been sent.
Yes, sir.
Which police station?
This is my lord. Tigriya.
Tigriya.
My lord.
All right. Learned counsel for the state submits
Deposition.
that he has is yet to receive instruction about the criminal antecedent. So also the instruction about the sufficiency of service of notice on the informant, and he has also not received the case diary. Put up this matter the week commencing from 11th March 2024.
In the meantime, 6 witnesses have been examined.
Okay.
I solved the copies and also
All right. Case diary instruction about the CA, so also about the sufficiency of service of notice in the meantime be obtained. Learned counsel for the appellant submits that 6 witnesses have already been examined in the trial court. Have you filed for the court?
Yes.
And he has filed the certified copy of deposition for the court.
That copy of the certificate.
Acha. Photocopy of the certified copy of the deposition for the court, and also supplied the Mr. Das, you received it to the learned counsel for the state. Put up this matter the week commencing from 11th of March 2024. Yes.
Item 16.
May please your lordship.
Yeah.
After 376 to end my lord and section 3 of the SCST Act, my lord.
You are appearing for the informant. Pass.
My informant is present, my lord.
Why have you? Is it a personal case of personal appearance?
No.
Then why did you call her?
My lord, you are also directed to.
Is there any order? Is there any order to call the victim? What is the offense here?
376 to end, my lord.
How did you dare to call the victim to the court?
Scheduled in 11, my lord, I have to obtain the 162 or not received. CD received.
The learned counsel for the state seeks some time to obtain the 164 CRPC statement of the victim. Put up this matter in the week commencing from 18th March 2024. Yes. Informant counsel has filed VNAMA, which is taken on record. Name of the learned counsel for the informant be reflected in the cause list. Yes.
Item 17.
Please, your lordship. My lord, on behalf of Mr. Panda, my lord, I may allow to place the bill.
Yes.
My lord, the case is under section 342, 376, clause 1, 294, 34 of the Indian Penal Code.
Notice sufficient, Mr.
No, notice is sent.
And you have received the case diary?
No, no. First time it has come.
Okay. First time it's not. Okay. And same 18/3/2020. Yes.
Item 19.
So item press SCST bill, please.
Press. Also.
Yes, lord.
Same order.
Obliged.
Issue notice. You serve the copy by tomorrow?
Yes, lord.
Extra copy?
Yes, lord.
18/3 it will come.
Yes, lord. Obliged.
You serve the copy by tomorrow, extra copy. And notice to be issued. It will come on 18th March.
Obliged.
With कर देवे 150. Yes.
Item 21.
May I please, your lordship, ma'am? This is a fresh bail application under SC/ST, my lord.
Okay.
This this bail application is it only because I could not submit the anticipated bail application. I was protected by an ABLPL, my lord.
Yes.
Since I could not submit the certificate copy in the right time, my bail, I was arrested and bail was rejected, my lord.
Whatever it may be, it's now it's a regular bail or
Yes,
not.
yes.
So notice has to be issued. So issue notice, extra copy,
I'm serving today, my lord.
served in during course of the
Yes,
paper
yes.
on the text like 18/3/2024.
My
Yes.
lord, 14th, my lord.
Next.
Obliged.
Item 22.
Maybe.
22, Mr. Nayak, yes.
Well, the petition is in custody, my lord, since 7/9/2020, almost 4.5 years.
You have received the case diary?
My lord.
Okay.
This is a case, my lord.
Is it the first application or is earlier rejected?
Earlier rejected, my lord, trial targeted.
Yeah, let
taking
me
into
see that.
consideration
What is that order?
My lord,
When
page,
it was targeted?
page 35 of the brief
Page 35.
by Honorable Justice Shashikant Mishra. Order dated 12/8, my lord, 2022.
Okay, the direction was to conclude the trial within a period of 8
8
months.
months, my lord. That is also in 22.
That is in 22. So
Taking
what
that-
is the position now?
Taking this aspect into consideration, my lord, your lordship wanted to release him for some 3 to 4 months or some days, my lord. Your lordship wanted for verification of the bailers, who are the bailers, and his address verification. Your lordship directed me to.
This man is an outsider.
Yes.
Okay.
Therefore, your lordship directed repeatedly, my lord, to file the address verification, my lord, the correct address of the petitioner as well as the address of the bailers. I have also filed that. Your lordship, flag P, my lord. Your lordship thereafter directed them to verify the correctness of the
Okay,
address.
so
I have already sent the letter to the SP Gajpati, my lord, but till late not received,
And
my lord. On
when
23rd February, I have
when
already
you
sent.
sent
23rd February, my lord.
23rd February.
Right.
So and they have provided you also the
Yes.
bailers documents.
Yes, my lord.
My lord.
So that also intimation must have gone to the IAC.
Already
for
sent,
very-
my lord. Already
that
sent.
report also you have not got.
No, my lord.
So I'm fixing it on
Your
11.
lordship, I kindly see your lordship's order sheet, but this is the 5th or 7th adjournment on this ground only. Your lordship say previous order, last chance, then previous orders,
No,
Five-
just a minute, Mr.
4 to
Nayak.
5 orders for the same purpose.
Just a minute. 23/2/2024. Yes, is right, Mrs. Sahu.
My lord.
There is a specific order. When I took up this matter on 23/2/2024, that was order number 7. And it is mentioned.
Just now received, my lord.
What receipt?
The instruction regarding the address verification.
What has been there? Whether the address is correct?
No response, my lord, has been received from the SHO. No response has been received from the SHO as yet, my lord.
ठीक है जी. What about the not दियंतु से जहाँ बुझिबे समान बुझिबे. What about the local sureties?
That I have also furnished.
No, it's all right.
Not yet received, my lord. Any subject review.
When I receive your lordship's order dated 18/8/23 from that.
So I'm keeping this matter. It will come in the supplementary list on 6th of March 2020. The
Lordship, it was already last chance. Then your lordship may say also no further.
no, but this so far this aspect is closed. Mr. Dharanidhar Nayak, land senior advocate, appearing for the appellant. Today, the land counsel for the state has produced the written instruction received from the Superintendent of Police Gajpati, dated 4/3/21, in which it is mentioned that additional SP Gajapati has been regularly contacting SHO over phone, but no response has been received from the SHO. and after steps are being taken to obtain the report early, and after receipt of the verification report, the same will be submitted to the office of the AG Odisha Cuttack immediately. This matter was taken up on 18/8/2023. And on that day, taking into account that the petitioner is a man from district of Hathras in the state of Uttar Pradesh, the London Council for the state was asked to obtain instruction whether the address furnished by the petitioner in the cause title of the bail application is correct one or not. And for such purpose, the Superintendent of Police Gajapati was directed to make necessary communication with the Superintendent of Police Hathras in the state of Uttar Pradesh and obtain a report. The matter was then adjourned from time to time, and London Council for the state took a number of adjournments to obtain instruction whether the address of the petitioner furnished in the cause title of the bail application is correct or not. So also, to verify whether the two local sureties whose names and documents were furnished to him by the London Council for the petitioner were whether the bailers were genuine or not, and whether the documents are authentic documents or not. When the matter was last time taken up by this court on 23/2/2024, it was made clear that no further adjournment shall be granted to the London Council for the state. It is a very sorry state of affair that after passing of the first order on 18/8/2023, when more than 6 months have already elapsed, the London Council for the state is unable to get proper instruction through the Superintendent of Police Gajapati regarding the correctness of the address furnished by the petitioner in the cause title of the bail application. Earlier, the London Council for the State, London Additional Government Advocate, assured this court in another bail application that at the secretary level, there would be talk with the other states so that immediate instruction can be received. And in spite of such assurance, the report which is furnished today by the Superintendent of Police Gajapati indicates that the counterpart is not giving any response in spite of the court order. The court expects that the Home Secretary shall make necessary correspondence with the Home Secretary of Uttar Pradesh to see that in future, wherever any such instruction is sought for, that is immediately attended to. Stop for Learned Counsel for the state submitted that the local sureties, instruction about the local sureties would be made available by day after tomorrow. In view of such submission, even though it was observed in the last order dated 23/2/2024 that no further adjournment shall be granted, I adjourn this case to 6th of March 2024. If the IIC doesn't furnish the necessary instruction, a proceeding under the Contempt of Courts Act shall be initiated against him. A free copy of the order be handed over to the Learned Counsel for the state for compliance. Yes.
Item 23.
May I please, Lordship? Lordship, kindly see the last order, Lordship. On the last occasion, Lordship was directed to State Council to verify whether some accused stands in the similar footing with the present petitioner.
Just a minute. So some bail order copies were handed over to you on the last date, and you are supposed to verify to answer the claim of parity.
As per the statement of PW7, my lord.
No, PW7 has implicated the petitioner and some of the co-accused persons.
My lord.
The co-accused persons, some of the co-accused persons have been released on bail.
My lord.
You have to verify whether the petitioner is similarly situated to
My
the.
lord, previously those person was released on bail. Name is Bhagat Kumar, my lord. The present petitioner name, as per the statement of the PW7 on para 6, was reflected on the SI asked about the identity of detainee person. They disclosed their name, Pavitra Mandal, my lord.
Which paragraph you are?
Paragraph 6.
Paragraph 6.
6.
6.
Okay.
तो गुट्टे देती है भगत कुमार आउट ही चाहिए.
Some persons were detained.
My lord.
Some persons were detained at the spot. And SI asked about the identity of the detained persons.
My lord.
You read that paragraph.
My lord, before that, my lord, on para 3, my lord,
Okay.
we were able to cut hold 36 number of people at the spot.
Paragraph 3.
Paragraph 3 on the last person, my lord.
Kahar evidence report.
PW7, my lord. One of the home guard, my lord.
7, paragraph 3, it starts with, then suddenly
My lord.
the persons gathered at the spot shouted to assault the police and started assaulting by means of thenga, lathi, tangia and other weapons,
My lord.
for which home guard was injured severely. For such and such blow, we rescued Banavasi from them and sent him to Mathili Medical in Bolero
My lord.
with Ranjan Khatri and Manoj Madhi.
My lord.
What do you want to show?
After that, my lord, just SI Maharana sir informed the fact to the IIC, Moithili and Oracle with a requested to send extra force to the spot. We were able to hold 36 numbers of people, sorry, my lord, 4 para, my lord. Peoples at the spot and rest of them fled away, my lord. On the spot, those person was hold. One person name was reflected on para 6, my lord, the present petitioner.
Come to paragraph 6 then.
My lord.
Please place.
Paragraph 6, my lord, on top line 2, my lord. Disclose their names as Pavitra Mandal, the present petitioner.
There are some names, lordship. I am permitted, lordship. Disclose the names as Pavitra Mandal, the petitioner. Raghu Khati, Budura Sorobo, Joydev Jani.
Who has been released on bail?
Released in lordship, the Gauranga Mandal, lordship.
Huh?
Gauranga Mandal, file BLAPL number 5596 of
No. Gauranga Mandala is also one of the person who has been detained, right? Is the Gauranga Mandal has been released on bail? Mrs. Sahu, have you been...
One bail copy was served to me, my lord, on Bhagat Kumar, my lord.
Gauranga Mandal.
Yes, my lord. If Gauranga Mandal, then similar footing, my lord.
Gauranga Mandal to achi na
my lord, similar footing, my lord.
So both the applications were allowed.
Lordship. The interim bail for a period of 3 months on the ground.
Just a minute. So they were granted interim bail. And have obviously taken into account the period of detention, which is also same because they are both of them were taken into custody from the spot itself. So, Mrs. Sahu, this detention period is same because both of them were caught at the spot. 8/9/2020.
My lord.
ठीक अछि तो?
My lord.
अच्छा. दोनों date of custody same. Spot रे दी जन धरा हितले same.
My lord.
सीए पाइची interim bail पाइची.
My lord.
But that person is a local man. Whether this man is also a local man?
Local man.
Kutigaram.
Gauranga Mandal was a local man.
Nabrangpur. So apart from that, what about the CA? Any criminal antecedent against him? This man. While not examining sponsors, I'm taking into account the period of detention and the slow progress of the trial. All right.
Nothing adverse, my lord.
Nothing adverse.
My lord.
All right. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 8/9/2020, and he has been charge sheeted under section 147, 148, 302, 307, 120B, 353, 149 of the Indian Penal Code and sections 20B2C oblique 25 oblique 27A oblique 29 of the NDPS Act. And in the meantime, trial has commenced, and out of 60 charge sheet witnesses, 10 witnesses have been examined. The learned counsel further submits that taking into account the delayed disposal of the trial, and the period of detention this court granted interim bail to one of the co-accused, namely Gauranga Mandal, for a period of 3 months in BLAPL number 8973 of 2022 as per order dated 22/9/2023. And since the petitioner is similarly situated, he may also be granted interim bail. Learned counsel for the state, after going through the evidence of PW7, so also the bail order copy of the co-accused Gaurang Mandal, fairly submits that the petitioner is similarly situated like the co-accused Gaurang Mandal, and he further submits that there is nothing adverse reported against the petitioner in the case diary. Considering the submission made by the learned counsel for the respective parties, in view of the commercial quantity of ganja and bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention of the petitioner in judicial custody, the slow progress of the trial, the fact that the petitioner is a local man, and further taking into account that similarly situated co-accused has been granted interim bail, I am inclined to release the petitioner on interim bail for a period of 3 months from the date of release, and the petitioner shall surrender before the Lennon trial court immediately on expiry of 3 months. Baki put the other terms and condition that he shall not indulge in any criminal activity and appear before the Lennon trial court on each date to which the case would be posted. And just add one thing, review the status report submitted by the Lennon trial court, which also indicates that out of 60 charge sheet witnesses, 10 witnesses have been examined. All right.
Item 24.
Mr. Lambodar Achyari, you have received the case diary
My lord.
and there is an application for interim bail. So,
Instruction obtained, my lord.
okay, the Learned Counsel is not there, so I am adjourning the case. Item number 24, non-appears for the appellant. Learned Counsel for the state has received the case diary, so also the instruction on the interim application. Put up this matter in the week commencing from 18th March 2024. Huh? Konda? But he is not responding, what can be done? The counsel is not there. Instruction is received on written instruction. The Learned Counsel files the written instruction, which is taken on record. All right, you do one thing. Put up on 11th of March 2020. This man is an outsider or? Item number 24. Oh, then it's all right. Ganjam. Okay. So it will come on 11th. Yes.
Item 25.
25 Om Prakash Saran. Yes, Mr. Saran. Yes, please. And you are having the case diary with you.
CD has not come.
Why?
On the last occasion, I have already sent the letter, my lord, on 29 February, my lord.
29th February, the matter was taken up.
My lord.
And it was adjourned to which police station it is?
Dhenkanal Sadar Police
So
Station.
Dhenkanal, you are not getting the copy from Dhenkanal. So I'm taking up the day after tomorrow.
My lord.
Ask him, okay?
My lord.
Mr. Saran, it will come on 6th of March 24.
Right, my lord.
All right. Heard Mr. Om Prakash Saran, learned counsel appearing through virtual High Court Dhenkanal. Learned counsel for the state submits that intimation has already been sent to the inspector in charge of Dhenkanal Sadar Police Station to send the case diary, and he has not received the same. In view of such submission, put up this matter on 6th March 2024. Yes.
Item 26.
Yes, Mr. Pujari. This 26 and 27 appears same petitioner. Yeah. So you have received the case diary.
No, my lord. CD has not come.
What is this?
I filed on 8/9/23. And the first order was at 17/11/23.
So
Regarding that, on 2nd March, I have already sent the letter, my lord.
hmm,
2 letter already sent, my lord, on 19 December 2023 and again 2nd March.
which police station?
Mohana Police Station.
Ask him to appear.
My lord.
Ask him to appear on 6th and send a case diary.
My lord.
Allah.
My lord.
This bail application was filed on 8/9/2023. It was taken up for the first time on 24/11/2023. And learned counsel for the state took time to obtain instruction to produce the case diary, so also to obtain instruction regarding criminal antecedents, if any, against the petitioner. The matter was then taken off on 15 to 2023 and then on 29 to 2024. And on each occasion, the learned counsel for the state sought for adjournment to produce the case diary. Today also similar prayer has been made. Put up this matter on 6th of March 2024. The inspector in charge of Mohana Police Station shall appear through virtual mode on that day and send the copy of the case diary immediately with the instruction regarding criminal antecedent, if any, against the petitioner by the next date. A free copy of the order be handed over to the learned counsel for the state for compliance.
Mr. Chief. 27.
6th February.
Item 27.
Okay.
Mrs. Sahu,
Sir.
when you are interested with a brief, okay,
My lord.
and you see that this type of order has been passed,
My lord.
you can get it through the High Court website, what order has been passed
My lord.
previously.
My lord.
So yesterday evening, when you saw that in spite of you, this court's order twice or thrice,
My lord.
that person is not sending of the case diary,
My lord.
immediately from the AG office, necessary information should have been sent to the IIC Mohana
My lord.
to send it. Why it is, if you will not do these homeworks, it cannot do. It's a question of regular bail. Somebody is in custody.
My lord.
Whether his bail will be allowed, rejected matter is something different.
My lord.
But for 6 months, 8 months for a case diary, if the matter is adjourned,
My lord.
then what will happen?
My lord, yesterday I have already talked with some of the officers. Some of the officers had told that recently I have joined. Some of the officers tell that I have transferred to any
That's a
other police
different
station.
matter.
That's a difficult matter.
They might have joined, but what is there for sending the case diary? And bring it to the notice if they are not doing, and bring it to the notice of the government advocate or AG
My lord.
that this is the attitude. They are not responding. Yes. Say this matter will come along with this item number 27. Huh? This is also same police station.
That was also my lord,
My
same police station.
Item 28.
Delay of 295 days. Due to whitewashing in the chamber of the lawyers, the file could not be traced out. In my miscase, paragraph 4.
What is this CRLA for?
CRL for release of the vehicle. Your lordship may kindly turn to the order of
No, the vehicle might have been disposed of in view of the order passed by the division bench. Are you aware about the present status?
no.
Are you aware that a division bench judgment has been passed, how this property of the NDPS Act seized, how they are to be disposed of?
No.
So then take instruction whether that property is there or it has already been disposed of.
Yes.
Okay. Because it's a 2016 matter.
Yes, yes.
You have received the copy of the CRLA.
No, my lord.
In course of the day, I will supply.
The Learned Counsel for the state submits that he has not been served with a copy of the appeal memo. Let the Learned Counsel for the state a petitioner appellant supply the same to the Learned Counsel for the state during course of the day. Stop.
Just now I am supplying.
All right, served in court. Since this criminal appeal has been filed under section 454 of the Code of Criminal Procedure, challenging the order of the Learned Trial Court for confiscation of the vehicle as per judgment and order dated 6/5/2015. Let the Learned Counsel for the appellant, in view of the passage of time, let the Learned Counsel for the appellant obtain instruction that whether the cause of action survives or not. So take instruction.
Oblate.
His house is open. Yes, next.
Item 29.
ଗୋଟେ ସପ୍ତାହ ପରେ ରଖିବେ.
Item 29 was the office in the report that the office is not maintained live before the district. I may be permitted within and file the appeal.
What you are challenging here?
The judgment of the
Judgment of the JMFC.
yes.
What is the offense here?
Due to the family disputes, my lord.
No. What is the offense for which you are found guilty?
I have not traced out the file by the PO Act. He was punished. He was a junior clerk.
Okay, you are convicted under section 323.
Okay.
And you are released on PO Act, right? So the appeal obviously lies to the Court of Session.
Yes, I will confirm with the final.
The Learned Counsel for the appellant seeks permission as per the report of the SR dated 24/5/2016. The Learned Counsel for the appellant seeks permission to withdraw this appeal to approach the Court of Session. In case such appeal is filed before the Court of Session within a period of 4 weeks from today, the Learned Appellate Court shall take into account Section 14 of the Limitation Act for consideration of the application for condonation of delay in filing the criminal appeal. Accordingly, CRLA is disposed of as withdrawn.
और इसे सर्टिफाइड करना है।
Yes, yes.
मैं डायरेक्टली रिटर्न द सर्टिफाइड कर दूं।
Certified copy of the impugned judgment be returned to the Land Council for the appellant on being substituted with a Xerox copy of the same. Yes.
Item 30.
Mr. Chand,
Please, my appeal agency judgment of acquittal. Case under
The-
section 307.
it is mentioned that it is to be a CRLLP.
372. So leave to appeal is not required.
Just a minute. Let me see that. So you are the informant. Prosecution has failed to prove its case so and so. Is it arises out of a PS case or
PS case, ma'am. Case 307.
let us see
Let
that.
me see. Criminal trial number such and such arising out of Jotney PS case number such and such. So criminal leave petition is required where not under 370.
No, it's all right. Why he has mentioned it like that?
Amendment 372 is the only.
And additional session judge, obviously the appeal would lie when it was pronounced.
No, it was 23, 26, 2016.
When that proviso was came into force,
Much before that.
372 law.
Amendment.
That is came in 31/12/2009. So obviously,
Much before.
So you have also nomenclatured your petition
Rightly
to
said,
be
criminal appeal because
372. You're right. So the stamp reporter's report is not correct. All right, take down. The stamp reporter has mentioned actually the petitioner is the informant. In Jatani PS case number 209 of 2013, out of which criminal trial number 195 of 2014 bracket A was instituted and accused S.K.SAHOO faced trial in the Court of London Additional Session Judge Bhubaneswar and by judgment and order dated 26/3/2016 faced trial under section 307/34 in the Court of London Additional Session Judge Bhubaneswar and by judgment and order dated 26/3/2016 he was acquitted of the charge. Mr. I am of the view it's not a case and is found not guilty, so on. So the accused is
Only on the
acquitted.
laches of the investigating officer.
Is
He has
not
seized.
guilty under section so on. So. All right. Proviso to section 372 of CRPC indicates that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused. Inter alia for any order passed by the inter alia for acquitting the accused, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. The appellant has filed the criminal appeal under section 372 of CRPC. But Mr. Chan, there are two judgments which you have annexed, and one is 195 of 2014A, that was of S.K.SAHOO is the accused, and that judgment was pronounced on 26/3/2016. The other judgment, which was against Gandu Mahanti, same day, but these are two separate judgments. So how can you file one criminal appeal?
Out of the same ballot,
Maybe the same occurrence it has taken place. If it would have been the same number, but the number is different.
because of the fact there was one during the mid of the trial, one accused has left.
It's all right, but
Split off.
if it would have been the judgment would have a consolidated one, and the same judgment would have been passed, since it's a two separate judgment. Maybe that there is some kind of difference also in the names of the witnesses, and the exhibits also might be different, and the nature of evidence, because one person was faced trial and the other person absconded. Subsequently, he came. So the witness might not be the same, or the evidence might not be also the same. There may be some difference between PW1 of the one accused and PW1 of this accused. Maybe that witness is same, let us say. But if it is recorded at different point of time, so the obviously the
If my lord scoring well. So for the witnesses concerned, it is one and the same. Total 1, 2, 3, 4, 5, 6, 7 are the same witnesses of the other case, my lord. And so for exhibit part is concerned also, the exhibit has also the same, my lord. Exhibit 1 is the FIR, exhibit 2 is the signature of the P1, and exhibit 2 is the injury, my lord, opinion.
No. I'm again asking you,
Of
Mr.
course,
Mishra.
my lord, ballot is right to this extent that because of the fact that no instead the combined judgment has not been passed, and the judgment
अच्छा आरो जजमेंट टा माने PW1 रो एविडेंस टा प्रथम केस रे जेतले रेकॉर्ड हैला सेतेबेले गोटे अक्यूज्ड अब्सकॉन्ड कला करितिला हां सेतेबेले धरा ही नथिला आ कोन ता परे आसिला बेली ता पर ए नंबर हैला नॉल तो सी गोटे टाइड अप कर दी था दीटा को कॉमन जजमेंट ही था it arises out of two different judgments.
One is Malad is right. PW1 in this that non-split up case 195 2014, it was recorded on 18/11/2014. And so far, after the split up, it is recorded on 14/1/2016.
So obviously, you confine this judgment, this criminal appeal to one only.
Madam.
So I'm observing that.
Madam, give me liberty to file.
You file another, only. But I'm holding that it is maintainable.
Obliged,
But
obliged.
Mr. Chand, learned counsel for the appellant, submits that this CRLA has been filed under section 372 CRPC, challenging the judgment passed by the London Trial Court, that is Additional Session Judge Bhubaneswar, in criminal trial number 195 of 2014 bracketary A, in respect of accused S.K.SAHOO, and by the same court in criminal appeal number 195 of 2014, the secondary A Rohun, in respect of co-accused Gandu Mahanti. And since those are two different judgments, there was necessity of filing two different criminal appeals, and therefore he confines this CRLA for the co-accused, for the accused. Kaha ko confine kariyo? All right. For the 195A, for the accused S.K.SAHOO, who faced trial in criminal trial number 195 of 2014 A, and acquitted by judgment and order dated 26/3/2016. He seeks liberty of this court to prefer a criminal appeal, separate criminal appeal, challenging the judgment pronounced by the London Additional Session Judge Bhubaneswar in criminal trial number 195 of 2014 in respect of accused Gandu Mahanti, who is respondent number 3 in this criminal appeal. Stop. Let the certified copy of it, a certified file let the certified copy of the impugned judgment in criminal trial number 195 of 2014 be returned to the London Counsel for the appellant on being substituted with a Xerox copy, and the name of the petitioner, the London Counsel for the appellant, shall file a phrase cause title excluding the name of respondent number 3, right? In view of the proviso to section 372 of CRPC, I find that the report of the stamp reported that the correct nomenclature would be CRLLP is not correct. This CRLA is maintainable. Accordingly, stamp reporting be made and matter be placed for orders oblique admission. Clear?
Item 31.
Yes, Mr. Panda, Jane Panda. What is the CRLA?
Conviction under section 304 part 2, my lord.
So that is been admitted or what? Or not admitted? Not admitted. So date of impugned judgment noted in the being aggrieved portion appears to be not correct. provision of law indicated in swans, not indicated. So the defects, where is Mr. Panda? Prisoner's petition at flag A for engagement of the counsel through legal aid. Congratulations, prisoner's petition. जेन पंडा को मोर केस रो दायित्व परिचालना करिया पई दिया आइतला किंतु अच्छा टंकार अभाव जो स्टेट लीगल एड तरफ वकील दबा पई चाहू छ अच्छा ठीक है मैटर रेफर कर दियन पेर यू द प्रिजनर्स पिटिशन टू filed by the appellant let the legal services authority so and so la members engage a counsel for the appellant put up this matter immediately after the counsel is engaged hala yes
Item 32.
Wait, please, madam. On behalf of Mr. Panda, I may be permitted.
yes
My lords, this is a post-conviction matter in which the substantial sentences of 12 conviction is under 20B2C of the NDPS Act with 12 years and the fine of rupees 1 lakhs, my lord. My lords, the petitioner.
please come to the operative part of the
My
judgment
lords, page 20 of
ये bound for SC टा मजरे मजरे
that's
yes
internal page 20, my lords. Internal page 20 of the judgment, my lords.
12
Page
years
17, 12 years. my
Hey, that
lords.
will be hala so RI for 12 years
My lords. With
fine is 1 lakh in default to undergo RI for 3 years 20B2C
My lords.
so how much period you have already undergone
Almost 7 years, my lords. I am in custody since the date of judgment. I was first taken into custody on 21/9/17, my lords.
you have never been released on bail
My lords, I was on bail for a period of almost 2 months, my lords.
2 months so if that period is excluded so you are remaining in custody for 7 years more than 7 years
Almost 7 years.
so have you got the custody certificate Mrs. Sahu
No, my lord.
so get it will take up which jail he is now
On good, my lords.
all right learn and counsel for the appellant submits that out of 12 years of substantive sentence imposed by the London trial court, the appellant has already undergone more than 7 years of sentence. London counsel for the state seeks some time to produce the custody certificate of the appellant who is stated to be lost in Angul jail. Put up this matter next week. Yes.
Obliged, my lords.
Item 33.
Good item
Mr.
33.
B.R. Tripathi. Yes, Mr. Tripathi.
Madam, the present petition
Paper books have been placed for acceptance. Vigilance appeal.
Paper books verified. Acha. Acha. Page
IN
the
number
report.
2973 of 2023 filed for early hearing.
हाँ
Filed for early hearing of the appeal that may be tested.
2019 अपील अभी कोर्ट सुनानी हो अपन पेपर बुक कहले हम फाइल करियो कर देलु पुराना अपील गुड़ा रही छी होइगा we'll take up this matter appeal after this summer vacation. Not now, it is not possible. So many criminal appeals are being pending.
Maybe added in the list.
Added about
Yes,
summer
yes.
vacation. You have received the copy of the paper book? Okay.
Paper book
paper
placed
you
for
collect it.
acceptance.
I am directing. Like on paper book filed, 4 sets of paper book filed by the London Council for the appellant was found to be in order by the registry, and therefore the same is accepted. London Council for the Vigilance Department submits that acha Sanjay Das ko na koti jibo. Okay, name of so and so be not reflected, and submit that he has not received the copy of the paper book. Let a copy of the paper book be supplied to the London Council for the Vigilance Department, and his name may be reflected. So far, itagala first like they then IA number so and so is an application for early hearing. Since the petitioner has filed the paper book, it has been found to be in order. Could of the criminal appeal be added to the hearing list after the summer vacation? Hello? Yes.
One set of paper book may be supplied to the applicant.
The London Council, the registry shall also supply one set of paper book to the appellant. Yes.
Item 35.
After summer vacation, huh?
Yes.
Yes. Certificate to be filed in the meantime. Last line, Hello?
Item 36.
Milo. Interim bail regarding the element of a wife, my lord.
IA number 1482.
Yes, my lord.
Is it coming for the first time or
No, my lord.
So
Kindly,
instruction was sought for
kindly, my lord, take a glance. Order dated 12/12/23.
12/12/23.
My lord. Order number 31, my lord.
Yes, I asked you, gave you time to obtain the fresh medical certificate.
I'm already filed and a copy also served in time, my lord. That is.
So what instruction you have received on the fresh medical documents which has been filed? Because it was of June. So I said that no, you file the fresh health condition report of your wife.
This medical document also not filed, my lord.
କହୁଛନ୍ତି ପରା file ହେଇଛି ବୋଲି report ଦେଖଉଛନ୍ତି
I
Have
will
you-
verify
have
from
you-
our office.
Have you got a copy with you?
Yes,
Just supply him in court. Make
Yes,
make
yes,
the
yes.
Xerox copy.
Yes,
That would be better. Again, if you search for it and doesn't find it, will
yes.
all right. The Learning Council IN number likhibe jota interim bail achi. That is IN number 1482 of 23. This is an application for interim bail. Let the Learning Council for the appellant supply the recent medical documents hala, in connection with the wife's ailment, appellant wife's ailment to the Learning Council for the state in course of the day, on receipt of which instructions shall be obtained. Put up this matter on 18th March 2024. ଦେଇ ଦିଅନ୍ତୁ ଆଜି ଆଣି ପ୍ରେସ୍ ମେଡିକାଲ ଡକୁମେଣ୍ଟ ୱାର୍ଡ ୟୁଜ କଲେ ତ ଓକେ
Item 37.
Lordship, I'm appearing on behalf of Gauri Mohanrat.
yes
Lordship, I'm filing the
surrender certificate. All right, the Learning Council for the appellant files the surrender certificate which is taken on record. All right.
Item 38.
Receive the instruction about the interim bail. On what ground you are seeking for interim bail? You do not know. Interim appellant is inside the custody since 3/2/2019 and convicted under section 376 2F. Your lordship may have a glance over the order dated 14/2/2023. My application was rejected and liberty was granted that after completing 14/2/2023. Yes, my lord. Your application was rejected. Rejected and liberty was granted after completing half of the sentence. So now you have completed. Yes, ma'am. Where is the custody certificate? Custody certificate. କେତେ ଆପଣଙ୍କ ହିସାବରେ କେତେ ହେଇଲାଣି 2/2/2019 ରୁ ବର୍ତ୍ତମାନ 2/2/2024 5 ବର୍ଷ ହେଇଗଲାଣି 10 ବର୍ଷ ସସ୍ପେଣ୍ଡ ସେଣ୍ଟେନ୍ସ 2/2 ରୁ ଆଚ୍ଛା so get that custody certificate କୋ jail ଟା ଖାଲି ଫୁଲବାଣୀ ଫୁଲବାଣୀ all right learned and counsel for the appellant submits that the earlier bail application of the petitioner in IA number 823 of 2022 no sir sorry my lord jail ଟା ଟିକେ ବୁଝିବାକୁ ପଡିବ କୋନ ସୋରଡା ଲେଖା ହେଇଛି କୋନ କୋଉଠି ଥିବ କହିପାରିବିନି ଭି ନାମା ରେ ଦେଖି ଭି ନାମାଟା ସାଇନ୍ ହେଇଛି ମ୍ୟାନ୍ ଅଫ୍ ଫୁଲବାଣୀ ବୋଧେ ହଁ ସେଇଟା ୟା ନାଁ ହେଲା ଭାଗୀରଥୀ ମଲ୍ଲିକ ଏଟା ଲେଖା ହେଇଛି ଫୁଲବାଣୀ डिस्ट्रिक्ट जेल फुलबाणी लिखा है फुलबाणी ये मैन ऑफ सोरडा तो सेटे कंफ्यूजन है हां नहीं 2022 रे फुलबाणी रो अटेस्टेड है सीट थीबो बोदे सीट ऑलराइट सबमिटेड ए से ऑर्डर बाहर करो जो ऑर्डर टा कहउथिले 14/2/33 हां while rejecting the application for bail in by order dated 14/2/2023 in IA number 823 of 2022 है liberty was granted to the petitioner to renew the prayer for bail if after serving half of the substantive sentence the appeal is not taken up for hearing. Learned counsel for the appellant submits that the appeal is not ready for hearing since paper book has not been prepared and in the meantime the out of 10 years of substantive sentence imposed by the London trial court, the petitioner has already undergone half of the substantive sentence. That is more than 5 years. London counsel for the state seeks some time to obtain the custody certificate of the appellant who is stated to be lost in district jail Fulbani. Put up this matter in the week commencing from 18th March 2024.
Item 43.
You can take note next week. You have supplied the deposition copies? Yes, it is there. Learned counsel for the appellant submits that he has supplied the deposition copies of the witnesses to the
Item 49.
49, Mr. Surjakant Das Mahapatra. Nobody is there. All right, non-obvious adjourn.
Item 50.
Ma'am,
Yes.
the last occasion manager called for a report as the petitioner filed as the surety for the accused.
Kono?
Surety of the accused.
He's an outsider.
Outsider,
Quebec, Koutiara.
madam. West Bengal.
West Bengal.
Madam.
So he was asked to obtain correctness of the address furnished.
Yes, that was
Also
called for
tell us.
Already done.
already.
Address verification already done, madam.
Address is correct.
Madam.
And what about the surety?
I prefer next week, madam.
Next week?
Madam.
Okay. And what is the sentence and what period he has already?
Sentence of 10 years.
And he has already?
6 years above.
All right. So, learned counsel for the state submitted on instruction that the address furnished by the appellant in the cause title is correct. However, he seeks some further time to get instruction about the local sureties whose names and documents were furnished by the learned counsel for the appellant. Put up this matter on 11th March 2024. Mr. Tripathi, next week. All right.
Obliged.
Pardon, Lordship, item 24, Lordship, non-appreciation.
Item
24, Lordship.
24.
Interim application thila, Lordship, non-appreciation. 11 तारिख दिन बाहागर अछि, Lordship. Let it be. Your Lordship is a...
आपण कार्ड बांटिया पळैथिले ना
delay.
आ आसिलेन रहिलेनी
Lordship.
आपण जदि एते अर्जेन्सी थिला बाहागर पई फाइल करछन्ती डका हला
Lordship.
So,
April 7 तारिख 7
एटाकू पहर दिन नै आसन
Lordship.
ए जोटा 24 तारिख टा 24 आइटम नंबर 6 टा 11 तारिख रखिथिली ताकू पहर दिन को नै आसन और नॉन अपियस टा काटी देबे हला यस
Item 51.
May I please, Your Lordship? The last occasion, Your Lordship was called for, was pleased to call for the custody certificate, my lord. The period of custody. Out of 10 years, 6 years, 6 months, 6 days. As on February 2024. 16 to 2024, 6 years, 6 months, 6
एटा गुडाई केस आपण नार अछि
Sir, 10 cases are other co-accused.
10 नै मडा 13 केस दिया 10
No, exactly not 13 million. That I have given an affidavit. Out of actually on the day police submitted the report.
6 वर्ष 6 मास 6 दिन सबु 6 अछि एटा केबेकार रिपोर्ट टा
February 2020.
सेंटेंस केते इज इंपोर्ट
10 years. 10. Out of 10, exactly the police has given including this case 13.
You are a local man.
I am a local man.
So सबु प्रॉब्लम ठीक अछि अभी जो केस वडा कथा कोन
Case I have given an affidavit. I have given any stringent condition you will
No. Comprehensive affidavit देइछन
Yes, I have given.
तो कौन केस रो पोजीशन सब कोन
All out of 10 cases he has acquitted in 4 cases.
Acquitted in 1 2 3 4 okay
And
released on bail
6 cases on bail and 1 case not an accused, 1 not yet registered even.
आपको गोटे काम करियो मासे जो क्रिमिनल एंटीसीडेंट पई मिस्टर त्रिपाठी let him go on interim bail for 1 month. If he conducts is good, then we'll extend it. All right.
The co-accused your lordship granted bail.
जानी चाहिए but in view of
your lordship as your lordship
IA number to and so this is an application for bail. Learned counsel for the state has produced the custody certificate of the petitioner, which indicates that the petitioner has already undergone more than 6 years, 6 months of sentence. It is dated hoji tarikh would purji
14/2. I have also received
14 to
16 to
16 to 24 hala. However, the out of 10 years of sentence all right. The learned counsel for the state, however, opposed the prayer for bail on the ground of number of criminal antecedents against the petitioner. Learned counsel for the state has filed, a petitioner has filed a comprehensive affidavit indicating that in some cases the petitioner has already been acquitted and in the other cases he has been released on bail. Consider
two cases he is not an accused in one case.
in some cases like that, in some cases he have been released on bail. In view of the submission made by the learned counsel for the so and so and period of detention, I am inclined to release the petitioner on interim bail for a period of 1 month. During the period of interim bail, the petitioner shall appear once in a week before the Gharagudi
Puri Chandanpur.
IIC Chandanpur police station, and the IIC shall keep a close watch over the activities of the petitioner. Put up this matter on such and such date, surrender certificate will be produced. The IIC of Chandanpur police station shall furnish the report regarding the conduct of the petitioner while on interim bail. Free copy of the order be handed over to the learned counsel for the state. Give the instruction. If the conduct is good, then he can get it. Otherwise,
let it be 6 weeks.
Huh?
Instead of 4 weeks, 6.
ঠিক আগে জান তো দেখুন সেই সপ্তাহে 4 সপ্তাহ. Yes, next 1 month bail granted. No question.
Item 52.
This is Mr. Mishra. This order is passed in only CRLA number 1103 of 2022 though.
Yes, yes.
কারণ তাদের ওটা connected matter আছে.
He has been released on bail. That,
Okay. So there is no nothing to it.
Connected.
ସେ ଅର୍ଡରଟା ଯୋଉ ହେଲା ମାସେ ସେଇ ଉପରଟାରେ କରିବେ ହଁ. Yes.
That's 52 on behalf of Mr. Pandey next week.
Next week.
Okay.
All right. You have received the deposition copies.
Well.
Okay. The mention is made on behalf of Mr. Devasis Panda to adjourn this matter till next week. Put up this matter on 11th of March 2024. Yes.
Item 53.
May I please, Lord?
Yeah.
Last time the Lords, may I prefer an urgent copy?
Yes,
my
yes.
Grateful.
Item 55.
May I please, my lord, I'm through virtual mode.
Yes.
My lord, in this matter, petitioner has filed a writ petition before the Honorable Apex Court, and the matter is still pending. On last date of hearing, Honorable Supreme Court has given 2 weeks time, and the matter is now listed on 15 March. I'm humbly praying can you adjust this matter after 15, my lord?
So then let it come on 27th March, madam.
Please, my lord.
Okay. Heard Miss Kiran Pandey, Land Counsel, appearing through virtual mode. She submits that the appellant has filed a writ petition before the Honorable Supreme Court, which is posted to 15th of March 2024, and she seeks for an adjournment of this application for bail. Put up this matter in the week commencing from 27th March 2024.
Please, my lord.
Item 56. Item 59.
That's kindly taken up the matter after 1 week.
Okay, it's a bail application. You have received the deposition copies?
My lord, received.
Okay. The learned counsel for the appellant seeks for an adjournment. Learned counsel for the state submits that he has received the case diary. When do you want out the 11th or 18th or any other day?
18th.
18th. All right.
I
8.
received the deposition copy, ma'am.
पहिले आपण रिसीव करते
Received deposition case diary.
केस डायरी कौन हबो
No, no.
ओके केस डायरी कोई दिली
Aye.
ओय सॉरी डिपोजिशन not necessary. Okay. Yes,
Next week, ma'am.
it will come on 18th.
Item 60.
May I please, Lords?
Yes.
Last occasion, my lord called for the status of
All right, rest of the matter after.
Apology. I beg apology to seek your leave, your lordship. For urgent matter, the mother was died on 21st. Your lordship granted interim bail, but due to the wrong name of the father's name, the order could not be complied with. Your lordship granted interim bail for a period of oblige, your lordship.
Item 61.
Lordship, item 61 in this case, the appellant number 3 was on interim bail and was to surrender on 1st February 2024. Meanwhile, Your Lordship, the Honorable Supreme Court of India was pleased to exempt the petitioner from surrendering by order dated 21/1/2024.
Which order he was granted interim bail?
Your Lordship, order dated 14/11/2023. And on the last occasion, Your Lordship was pleased to extend the interim bail.
Take down. The petitioner was granted the petitioner number 3, Brismohan Gupta, was granted interim bail for a period of 2 months. As per order dated 14/11/2023 in IA number 1815 of 2023. And the same was extended till 31/1/2024 in IA number 3087 of 2023 as per order dated 11/1/2024, and the petitioner was directed to surrender before the Lennon Trial Court on 1/2/2024. The Lennon Counsel appearing for the petitioner number 3 submits that against the order dated 11/1/2024 passed in IA number 3087 of 2023, the petitioner approached the Honorable Supreme Court in special leave to appeal criminal appeal number 11878 of 2024. And by order dated 29/1/2024, while issuing notice the Honorable Supreme Court has exempted the petitioner number 3 from surrendering. The copy of the order of the Honorable Supreme Court dated 29/1/2024 is produced, which is taken on record. Land Counsel for the Central Government Senior Panel Counsel is present, है ना? Land Central Government Senior Counsel.
Yes, my lord.
Or you
On behalf of Partha Sarangan, NCB, my lord.
Is present. He has come today to court.
Yes, my lord.
Is present. In view of the order passed by the Honorable Supreme Court, place this matter in the week commencing from 8th April 2024. The Land Counsel for the petitioner number 3 shall apprise this court about the development made before the Honorable Supreme Court in the case instituted by him. Yes.
No, pleased.
You filed on a date that jana pe prominently kon asura nahi. हाँ? ये तक कौन ये करना? अरे डेट जना पड़े. That is your responsibility.
Item 62. Item 63.
Item 63, my lord, there is a prisoner petition.
Prisoner's petition.
My lord.
Regarding engagement of Advocate Dhirendra Kumar Mahapat.
No, I am Abhilash Mishra. Myself. So my power may be withdrawn, my lord.
No, where is Mr. Mahapat? You are there. So have you filed your Vinama?
Yes, sir.
Vinama achhi dekhi. All right. Period the prisoner's petition received from District Jail Bhubaneswar regarding engagement of Advocate Dhirendra Kumar Mahapatra in state of Abhilash Mishra. The Mr. Mahapatra has already filed Bhinama. In view of the state of affairs, the name of Mr. Abhilash Mishra and your associates' names are there, and the name of
BP Panda,
his associates, namely
BP Panda,
BP Panda.
D Behra, and M Mudil.
ये देखिए ठीक से कौन तुली अपन मनकर अपन का एसोसिएट की अपन कहले मुदा नाटा काटी देबी ए जांको कॉज लिस्ट नाही की अपन
कॉज लिस्ट जॉन कोना ना अछि अछि
ना
ना अछि जो अछि कोइ दोछि M Mudili.
M
Muduli.
M Muduli shall not be reflected in the cause list henceforth. Yes. You want to move the bail application today?
No, my lord. First of all, we have to obtain the to deposit the question.
The London Counsel for the London newly engaged counsel seeks for an adjournment. Yes.
Deposition copy. My lord, enter file I'm handing over to email.
Okay. You hand over it. That is your. There no need to pass any order. You just hand it to the London Counsel for the appellant. Shall supply the deposition copies of the witnesses to the London Counsel. Take the brief and hand over the copies. Yes.
Item 64.
64
Item 68.
That's in item 68. I had stated on the last occasion that the appellant has died, and I have sought for instructions with regards to substitution. That instruction has been received, just waiting for the legal heir certificate and the wakalatnama. Next
Alright.
week, my lords, I'll file the IF for continuation of
Mr.
the day also.
Sudip Tupandal and counsel appearing for the appellant seek some further time to file an interim application for impleading the near relatives of the deceased appellant to continue the appeal. Put up this matter in the week commencing from 8th April 2024.
My
Yes.
lords may indicate if any IA is filed, it may also be tagged.
If an
Grateful, my
interim
lords.
application is filed, the same shall also be placed on record for appropriate
Grateful, my
purposes.
lords.
Item 69.
69, your lordship, kindly taken up 1 week after.
You have supplied the deposition copies. Item number 69 deposition copy paichanti.
Yes.
Okay. Land counsel for the appellant 6 for an adjournment April the day.
Item 70.
70 Mr. Ashwini Kumar Das. Nobody is there. Huh?
Also, copy not served. That is vigilance matter.
ମୁଁ ତ adjournment ଦେଇନି. All right. Non-appeals କରି adjourn କରିଦିଅନ୍ତୁ. Yes.
Item 71.
Lordship, on behalf of Mr. Das, I pray for 2 weeks' time.
2 weeks time.
Yes.
So it's a criminal appeal, bail application, deposition copy.
Item 74.
Chandana Mishra.
Please, Your Lordship.
Deposition copy ଦେଇଛନ୍ତି? Yes, Mr. Kumar.
There are still a few more months left for him to complete.
Half of the sentence. କେତେ ବର୍ଷ ହେଇଛି କି?
10 years.
10 ବର୍ଷ ହେଇଛି, 4 ବର୍ଷ 74 ଦିନ UTP, 7 ମାସ 5 ଦିନ convict ହିସାବରେ।
ତାହେଲେ summer vacation ପରେ ନବା। Out of this matter after ensuing summer vacations.
Co-accused ମାନେ ସବୁ bail ରହିବ।
Co-accused ମାନେ
Co-appellants ମାନେ ଯୋଉମାନେ convict ହେଇଛନ୍ତି co-convict
ସେମାନେ କଣ?
ସେମାନେ ଇଏ ଟିକେ bail ରେ ରହିଯାଇଥିଲା ତ।
ଆଚ୍ଛା ଠିକ ଅଛି। After summer vacation. Yes, next.
May I pray, Your Lordship, may call it in the last week of June.
ଜୁନ ଶେଷ ସପ୍ତାହରେ ପକେଇଦେବେ ଗୋଟେ ଯୋଉ ସୋମବାର ଦିନ ହେଲା। Yes.
Item 75.
Yes, Mr. Tanmay Kumar Mahan.
Item 75, may I please, my lord?
Item 77.
Yes, Mr. Ashwini Kumar Das. ଏଇ ପରା ନଥିଲେ ଆଉ ଗୋଟେ ମ୍ୟାଟର କୋଉଟା ଗୋଟେ ହଁ ସୋ ଏଇଟା ନନ୍ ଆপিୟସ୍ କରି ଆଡଜର୍ନ କରିଦେବେ
Item 78. Item 80.
Item 80, Mr. Gauri Mohan Rotho.
Appearing on behalf of Ms. Oriman.
What do you want?
Lordship, last occasion, it objection to IA was supposed to be filed. It has not, like we have not received the copy.
What was supposed to be filed?
Objection to the IA.
How much delay is there?
Your Lordship, according to us, it's 464.
460. कौन हला फाइल करेगी objection? OPID council, yes.
OPID.
What order you are challenging?
Challenging order of cognizance, my lord. It was
11/11/20.
And today filing the lord objection.
Objection.
Again.
Sorry, may copy let him
Just
go.
now, put extra copy.
And Mr. Patro, this order is under challenge is dated
11/11/21, page 17. my lord.
page 17. Let us see that. 17 number page question. What the back? Bas. So cognizance of offences have been taken, right? So if that order was passed on 21, we are now in 24. So whether charge has been framed, any development has been made, because there is no stay order. So you also obtain instruction about the status of the case, because if the charge has been framed, then this automatically this goes. He has to file.
30 million total million charge sheet is 13 million.
अरे आपण चार जगह फ्रेम हेलानी नहीं बुझंतु कॉग्निजेंस ऑर्डर चैलेंज करचंदी 2021 रो हला लेखन IA number so and so this is an application for condonation of delay. Land counsel for the state filed the objection to such condonation application, which is taken on record. Copy of the same has been furnished to the London counsel for the appellant in court, who seeks some time to go through the same. The order under challenge in this criminal appeal is dated 11/11/2021, passed by the London presiding officer designated court OPID Act Cuttack in such and such case, in taking cognizance of offences punishable under section 6 of the OPID Act. Acha nahi, 420 120B of the Indian Penal Code, read with section 456 of the Price Cheats Money Circulation Act, so also section 6 of the OPID Act. The London counsel for the state seeks some time to obtain instruction about the status of the case, put up this matter in the week commencing from 18th of March 2024, on which date the interim application for condonation of delay shall be considered.
One thing, I tell you, total charge sheet is 13 million. They have given the deposition of 12 million.
Deposition?
Yes, kind of last page, you know.
What are you saying? I could not follow.
ଏଇଟା ଯେତେବେଳେ ଆଗରୁ ଗୋଟେ ଚାଲିଥିଲା ଯୋଉଟା ତାପରେ ଏଟା OPID କୋର୍ଟ କୁ ଟ୍ରାନ୍ସଫର ହେଇଗଲା
କଗ୍ନିଜେନ୍ସ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ସେ ଗୋଟା କୋଉ କେସ ର ଏଇଟା କଣ ଏଇଟା କଣ what is this offense ଏଇଟା କଣ ସେଇ accused ର ଚାଲିଥିଲା ଆଗରୁ ଓ it may be ଶୁଣ ସେଇ accused ର ଆଗେ normal court ରେ ବୋଧେ ଚାଲିଥିଲା then maybe that it was found out that one of the ଆପଣ ବୋଧେ petition file କରିଛନ୍ତି କଣ 6 OPID Act make out ହଉଛି କଣ ସେଇଥିପାଇଁ ସେ ହୋଲ୍ଡ କରିକିନି ତାକୁ ପଠେଇଛନ୍ତି ସେଠିକି ତ ଦେଖନ୍ତୁ କଣ ହେଇଛି ହେଲା କାରଣ ଗୋଟେ କୋର୍ଟରୁ ଆଉ ଗୋଟେ କୋର୍ଟକୁ ଆସିଲା ପରେ obviously fresh trial ହବ ସେଟା ପେଣ୍ଡିଂ ଥିଲା CGM କୋର୍ଟରେ କାରଣ ସେ ଅଫେନ୍ସ ବିଷୟରେ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ହୁଏତ ଆଡ୍ୟୁସ୍ ନ ହେଇଥିବ କଣ ଯଦି ହେଇଥିବ ଅଳ୍ପ ହେଇଥିବ so it is to be again if charge is framed then again all the witnesses are to be summoned and they are to come and depose again, right? So कौन position अच्छी तब देखो है ना 18 ତାରିଖ ଦିନ ଆସିବ 18th March 2024. Yes. Status of the case.
Item 81.
81, Mr. Das.
The appellant has been convicted under section 363 by 370.
Supply.
Item 82.
The applicant file a interlocutory application 82 Miller.
Konta?
82 Miller.
Ah.
Appellant file a interlocutory application for Miller interim bail on the ground of Miller illness of his Miller daughter who suffered in Miller blood cancer Miller.
Just a minute.
IN number 2980.
So instruction was sought for. Yes, Mr. Das. कौन आसला report? कोड यालो कोई है?
फुलबाणी Miller. फुलबाणी Miller. List of Kenwaga, list of Kondhamara.
All right, take down. IN number 2980 of 23. This is an application for interim bail on the ground that the daughter of the petitioner is suffering from so and so acute lymphoblastic leukemia, that is blood cancer, since 2018. And for a treatment, the presence of the petitioner is very much necessary. And counsel for the state has obtained the report from the Deputy Superintendent of Excise dated 29/2/2024, which indicates that the associate professor, assistant professor of officiating unit head, pediatric hematology and oncology, has opined that the daughter of the petitioner, who is aged about 9 years, is suffering from acute lymphoblastic leukemia, and she requires medical oncology and hematology department request treatment ಅಲ್ಲ? She to come to the medical oncology and hematology department in every 6 months for follow-up checking. It further appears from the report furnished that जो प्रथम रिपोर्टर लिखिदेवे that the brother and father of the petitioner are dead, and only son of the petitioner, who is a student of class 9, is there in the village, in his house. Considering the submission made by the learned counsel for the respective parties, the amendments taken in the interim application, the medical documents annexed thereto, and the report furnished by the learned counsel for the state, I am inclined to release the petitioner on interim bail for a period of 2 months. We will file the surrender certificate, and that is IN number 298023. Yes, next.
Item 83.
83. Yes.
Item 95.
Mr. Yes.
May I please your lordship? I have been convicted under section 366, 376D, 363, and section 6
What-
of the POCSO Act.
What is the sentence imposed?
20 years and
20
as
years.
well as 5 years.
You have supplied the deposition copies?
My lord, I have twice.
So you were on bail during trial?
My lord.
Are you
No,
on
no,
bail?
I have
You
not
are in
been-
custody?
I was in the custody.
How
since
many years you have been in
custody? 8 years, 2 months.
8
15
years. So 8 years in custody. And who is the victim?
The victim is the PW1.
PW1. Who is the doctor?
Doctor is PW3. I just wanted to submit. So, actually, the incident occurred on 13th November 2013. The victim came back to the home on 17th November 2013. But the FIR was given on 28th December 2013. That is after 1 year, 1 month and 4 days. Even though there is no, that victim has disclosed immediately that they have taken and all these things. As per the
Just a minute, let me.
but they have not talked. The doctor is saying.
Just a minute, just a minute.
My lord.
Wait.
Oh.
3 persons, including the petitioner, committed rape on the jungle. So is it a case of gang rape?
Yes, sir.
No. So what instruction you have received about the criminal antecedent?
I have not.
And also get that custody certificate. What the London Council says,
Neither.
it is more than 8 years. Right?
Right.
London Council for the appellant submits that the appellant is in judicial custody for more than 8 years. Let the London Council for the state obtain the custody certificate. So also the instruction about the criminal antecedent, if any, against the appellant, put up this matter in the jail in which jail your client is there?
That is Balangir jail.
Balangir jail. All right.
My lord, just I wanted to say that the medical report says it is a clear cut.
Next week, when the matter will be hard, you argue on that.
Okay.
Just
Oblige.
Adjourn to next week, man.
custody certificate.
Adjourn to next week.
You cannot get
1
it.
week.
Okay. And then 18th, let it come. All right. Custody certificate and CD. CA, criminal antecedent, 18 March 2024. Yes.
My lord, oblige.
Item 96.
96, Mr. Jyotirmoy Sahu. Yes.
I beg pardon, my lord. Item 86, 91, 96.
ସବୁ ନନ୍ ଆପିୟସ୍ ହେଇଛି ଆପଣ କ୍ଲାଏଣ୍ଟ
କାଲି
ଦେଖିବେ
ଯାଏ
କ୍ଲାଏଣ୍ଟ ଦେଖିବେ ଅପଲୋଡ ହେଇଥିବ
ମୋର ସରି କାଲି ମୁଁ କରୁଛି।
ଏଗୁଡାକ ସବୁ ଯୋଉ ଅପଲୋଡ ହେଇଛି ଏ ସରି ନନ୍ ଆପିୟସ୍ ହେଇଛି ତ କାଟିଦେବେ କୋଉ କୋଉ ଆଇଟମ କୁହନ୍ତୁ
86, 91, 96
ହେଲା
ଏଇଟା
କାଟିଦେବେ
କାଲି ଆସିବ
କାଲି ସବୁ ନେକ୍ସଟ ୱିକ୍ ହେଇଛି ସବୁ ଆସିବ ସେ
ନେକ୍ସଟ ମଣ୍ଡେ।
ହଁ